Good afternoon, everybody. My name is Chris Justice, and I'm here again today to join you for another session where I will, as always, try to answer as many questions as possible. I'm, as you see down below, an employment lawyer with Samfiru Tumarkin. I work out of their Toronto offices. And yeah, so definitely get in your questions, anything employment law related. It could be something to do with maybe an issue going on with a possible employer in the future. Maybe you want to have a contract reviewed, or you're wondering about certain language in your contract. Could be something, situation that you're experiencing in the actual workplace itself. Maybe you're being bullied or harassed by a boss, or it could have to do with maybe a question around your termination entitlements, what is fair and reasonable, and also maybe any other questions after employment ends that you might have. So definitely get your questions in. As I say, I'll do my best to answer as many as possible. As I usually do as well, off the top, I like to start with a couple sort of main topics, trending topics that are going on right now in the employment law world, and sort of how that affects employees and employers alike. And one of the things that I've been noticing in my line of work has to do with the fact that a lot of employers are downsizing as a result of their, I should say, as a result of COVID to some extent. They're sort of moving locations, office locations. A lot of people I've spoken to have been sort of working like out of, let's say, a Toronto office for the longest time, but for whatever reason now they're being told, whether again it's COVID related or financially related, they're being told that the office they used to work in is no longer available, and that they're having to now report to work at a different office. I've had other situations where employees have been off, I guess, or I should say, working from home remotely, away from the office, and they're being told to have to come back into an office that's in a different location than where they were at. And so these are just examples of changes that can happen to the terms of someone's employment. As I say, it could be a location change. Your office is switching around. It could be maybe a change to your compensation in some way. It could be a change to the nature of your job or the duties and responsibilities that you have in that job. And it's important to know sort of what to do in those circumstances when these changes are happening. What are my rights? And specifically, let's use the location example again. It will come down, and this is the case for most changes, it will come down to the degree of the change. So say, for instance, you're working at a location in Toronto and your employer tells you that they're changing locations and they're going to be doing business in the building, say, next door to the one that you're working at, everything else being the same. That's probably not going to be viewed as an issue, as what's called a big change or a significant change. On the other hand, if you're working in Toronto and you're being told now that you're going to have to commute to, say, Barrie, well, I mean, that arguably would add an hour or more onto your commute time, depending on where you were located, and may not have been something at all envisioned previously. So that's a completely different situation. And then you as an employee in a situation like that, where you're being told to go from, say, Toronto or Barrie, or, maybe a relatively similar distance elsewhere, you're going to probably have an option then as an employee to say, well, no, I don't agree to do that, and I want my severance instead. Or, the converse, which is just you agreeing to it or maybe trying to negotiate some compromise. But you still would have the option to essentially exit that situation and treat that as though it's been a termination. Now, before you do that, before you leave any situation, anytime there's a change in your employment, you want to talk to a lawyer. You want to get advice. You don't want to just abruptly leave the office or just abruptly send an email to your employer saying you won't be doing this or you won't be agreeing to that change. You should definitely call a lawyer first, get some advice. But there will be likely options for you to communicate going forward as far as maybe what you want to do. Again, do you want to object to it? Do you want to agree to it? Do you want to negotiate some middle ground? So this applies, like, as I say, it could be an office location. Your employer could change your compensation package, and it might be to such a minor degree that it's not considered an issue in law. But then on the other hand, you could take a pay cut of 20% And then all of a sudden, that's a significant change, no doubt about it. And again, you as the employee would have the option to treat that as though it's a termination at law and essentially get your full severance. So yeah, whether you're dealing with location changes, comp changes, just your job changing, duties being taken away or being added onto your plate, give us a shout, get some advice, because for the most part, you do have options. And if you've been with a company for a long time at that point, your potential termination entitlements, your severance entitlements, they can be very big, very big. Now, when it comes to the issue of, what your severance entitlements are, if something like this happens, what do I get? If I lose my job, if I'm just let go and I'm just told by the company, we're letting you go without cause because we're doing a restructure, we're doing a reorganization, what do I get? That's going to come down to a number of, 3 or 4 key factors. And I know there have been a lot of mass terminations and layoffs on the rise of recent days. And so I think it's important to know, as it is always, what is a fair and reasonable package. So one of the things I first look at, though, is the contract. Did somebody, whether they're officially being terminated or they're being, the terms of their employment are significantly changing and they're considering leaving and saying no to that change, what contract is in place? What does the termination clause say? Is there language in that contract that limits you or limits your rights in some respect? That's usually the starting focal point I'll look at, because a lot of times people sign contracts, and a lot of times in those contracts there will be a termination clause, and the goal of that clause is to essentially entitle you to just receiving the bare minimum that's permissible or required under law, I should say, rather than what your potential maximum could be. So for instance, there could be a scenario where your bare minimum entitlement would be 6 weeks under law. But had it not been for the fact that you signed the contract, you could actually potentially get 6, 7, 8, 9, 10 months. So there's a very big difference for the most part between what the law says you're owed at minimum and what the law says your potential entitlement could be. And that's why it's very important before you sign any contract, especially one with a termination clause in it, that you review that with a lawyer first, and that you make sure that at the very least, if there's going to be a clause like that in your contract, that you're not, it's not being worded in a way that would drastically affect your rights. So that's one thing, as I say, I look for is there a contract? What does it say? Now, I will say that for the most part, most contracts do not effectively limit someone's rights. So if you're worried, you're out there, you've got a contract, you've signed it, vast likelihood is that will not materially or significantly affect your rights in any way. It's very hard, or at least it's very rare, relatively speaking, to see contracts that are drafted or worded in a way that would effectively limit your rights. So I'll just say that to begin with, but still the contract is always that starting point. Now, assuming your contract doesn't affect you in any way, there are 3 or 4 main factors that will dictate or determine how much severance you should get. Number 1 is age. So typically for people, we'll say in the age range of 50 and up, you'll typically see a bump in the amount of severance that they would be entitled to as sort of their potential. So age is number 1. Length of service, of course, is another. So the longer someone's with a company, typically the more severance they're owed. Although I will say that if you are somebody who has only been with a company for a very short period of time and you're let go, and you might think, well, I've only been there for 6 months or a year or 2 years, I'm probably not owed that much. It's important to know that shorter service employees are typically given disproportionately larger severance packages. So just to dispel any myth out there, if you're someone who doesn't have a lot of time in with a company, it's still very possible for someone like that to get 6, 7, 8, 9, even 10 months of severance. But length of service is still another factor. And so again, typically the more service you have, the more severance you're entitled to. The third factor is the position that you held at the time that you were let go. So say you're working in a minimum wage job versus working as a CEO at a company. If both of those people are let go, in theory, the person working the minimum wage job would have a easier time finding work if everything else is equal. And then there'd be less availability of similar CEO roles for that other individual. So depending on what your position is at the time you're let go, and because you're normally expected to try to look and find a job similar to that after you're let go to replace those earnings, the job you have and the availability of that job in the workplace or the marketplace is going to be another factor into deciding how much severance someone should get. But the maximum essentially in this country is between 24 and 26 months of severance, which, as I say, is a huge amount. You could be a long-term employee, and you could be potentially entitled to as much severance as that. And that's even despite signing a contract, despite anything like that. So, especially if you're a long-term service employee, again, you want to make sure that you're getting what's fair and reasonable. And a lot of times when people are let go, they're told what's being given to them is fair, until they speak with a lawyer and discover that actually the employer owes them double, triple, or quadruple what they're willing to offer initially. So yeah, very important. Termination clauses, very important, obviously, to understand what your rights are. And again, just going back to what I said at the outset, if you're sort of put in a position where there are big changes being made to your employment, don't feel as though you need to accept those changes or for fear that you might not get anything or that you might be seen as having quit. You do have options. So give us a call and we'll be happy to go through all those with you at that time. I'll get into a little bit more later on, some topics that I was going to talk about off the top, but I do want to get into some questions. I just see here a number of questions, so I want to get to as many as possible. The first question I've got is from Ashram through email, who's asking whether or not they should sign a new employment contract for their position. They've been working with the company for 3 years already without a contract. And now there seems to be a shift in management, and they want a number of employees to sign new contracts. Should I sign it? Is there anything I should be worried about? So I just finished talking about one thing employees should be worried about when it comes to contracts, which is termination clauses, because of their potential impact on limiting your rights when you are let go or if you are let go. So that's one thing, whether it's an opening for a position that you're just applying to, or you're in a situation like Ashram where you've already been working for the company for 3 years. So termination clause is huge. But in general, especially if you're mid service and your employer is approaching you and asking you to sign a new contract, you need to be wary about what benefit is going your way. Typically when someone starts a job, before they start the job, they sign a contract saying, we'll pay you XYZ money. This is what you're going to do. And in exchange, we'll give you this contract. So there's kind of a give and take there. It goes both ways. But when you are already in the middle of your service with a company and you're being asked to sign a contract, and there's going to be no change to your pay or no change to your job, it's not like a promotion's happening, and it's just seems like you're being told it's just for paperwork. We're a new management. We're coming in. We just want you to sign something so we have it on record. You definitely want to be cautious. You don't want to sign anything like that. You want to have it reviewed by a lawyer, because you could be potentially giving away a significantly greater amount of your rights that you had before without a contract, that are now being taken away, first of all, by virtue of this contract. But you also want to make sure that you are getting something in exchange for signing that contract. If you're not getting something, then there's actually a possibility that the company won't even be able to rely on that contract later on. This might be something more helpful for people who might have already signed a contract. If you've been in a role without a contract and you've signed another a first contract, sort of 3, 4, 5 years in, whatever it is, and you're worried about the effects that might have on you, just remember that there typically has to have been a benefit going your way when you signed it. And again, that might be another situation for you to give us a call and we can talk to you about it. But again, Ashram, mid duration, being told to sign a contract, you kind of want to understand what the basis for it is and whether you're getting any benefit. You want to make sure that you're not signing a new contract that might, God forbid, lower your pay, be viewed in any way as a demotion, maybe, there's a job description attached to your new contract with a completely different sort of job description than what you were used to before. So signing a contract mid-duration, it just creates a whole host of problems when, a lot of these things are added and you have no idea that they could have the effect that they did. So it's always a concern generally when someone's being approached to sign a contract mid-service. Now there could be good reasons, Ashram, you could be given a promotion and a pay raise, and in exchange they want you to sign a contract, and that would be more likely viewed as being enforceable. But still, at the same time, it might have terms in it that affect your rights and, for example, your termination rights. So I think if, again, you're someone, whether it's a fresh hire or mid-duration service, and you're being presented with a contract to sign, give us a call and then we can take you through it, just to make sure at the very least you know what you're signing, what effects it'll have going forward, and maybe how it'll be different than what it was like before. And then at least you're fully informed and you can make a decision at that point. I've got another question in from Fatima on YouTube, who's asking whether or not they can be terminated while on sick leave. And what I would say is, in most scenarios, that's going to be seen and viewed and considered to be completely discriminatory. And at the very least, in probably all scenarios, it's going to look extremely bad on the company who terminated someone while on a sick leave. It could be technically possible to be terminated on a sick leave if it's for no reason related to the sick leave. However, if the employee can show that even 1% of the reason why they were let go was because of the fact that they went on the sick leave, then that would amount to discrimination under human rights legislation. And then if you're someone and you've been terminated for a discriminatory reason based on, say, going on a stress or a disability leave, and you have the evidence to prove that, then absolutely you would be entitled to severance on account of the termination. You would be entitled to human rights compensation as well for violating your human rights under the human rights legislation. And you could even be potentially entitled to other damages just for the general bad faith circumstance of the termination itself. So it's always tricky because, companies are in almost every case, if not every case, going to deny the existence of any discrimination whatsoever, even if it looks plainly obvious. And so at the very least, you would have to expect somewhat of a little battle, for the lack of a better word there. But yeah, absolutely. The optics would look terrible. And there would certainly be a lot of risk on the company that did that, that a judge would see it in a very similar fashion. So Fatima, if you are in that situation or know anyone else that is in that situation, 100% give us a call, because as I say, there are a number of different ways that you might be entitled to compensation. Because yeah, it seems like clear discrimination in my eyes. So thanks for your question. I've got another one in from William on YouTube, who's asking what happens when your employer doesn't send you your work profile to your lawyer on time. So William, it seems like you have some sort of ongoing legal dispute with your employer and you are requesting a work profile. Normally when someone sues a company, or when a lawyer on behalf of their client sues a company, there comes a point in time where you have to exchange all relevant documents that you have. In the employee's case, we might be talking a T4, a record of employment contract. Employers might have the exact same stuff. And in William's case, maybe your employer has a copy of your work profile that they appear not to want to send to your lawyer on time. So it'll depend, William, if you've already sued the company or not. Because as I say, if you've sued them, then there are actual mechanisms in place to force them to provide all relevant information. And if they don't want to do it within a certain time frame, a lawyer could get the courts to intervene and demand that potentially that profile be produced by a certain date and no later than that. If you're asking for information from your employer and you haven't yet sued them, technically they could refuse to provide that information. Depending on who your employer was, you could do a search and possibly get the information without a lawsuit, but otherwise it might be tricky. But without further info, William, that's probably as best as I can answer your question. I thank you in any case. I've got another one from Carrie on YouTube who's asking whether or not working remotely for a company can change the type of law that you have to work under if your employer is in a different country or province. So that's a good question, Carrie. Definitely, there are circumstances, for example, where you may work for a U.S. company, but you yourself are based out of Toronto in Canada. And you may only deal with U.S. clients, but still your location's in Canada. There's a very good chance that your employment, the terms of your employment, will be governed by the province of Ontario in that hypothetical that I raised, and not necessarily by any means based on the law of where, let's say, your company's headquarters are located, or where your company's just based out of. Usually there's also a contract involved that might speak to which law is applicable. A lot of times when people sign contracts going in or at any time, usually near the end of the contract, it might say what the governing law of that contract is. So that could clarify perhaps whether it's Ontario, for example, or otherwise. Not to say, though, that contract means that's what the law is. There might be a dispute there. But I would say in most cases, it's typically where you yourself are situated versus rather than, I should say, where the company's located. But without maybe more details and without maybe having reviewed a contract, Carrie, that's probably as best as I can say right now. It does technically depend in certain situations, but for the most part, I find that the connection is mainly where the person's working. But I look at the contract as well. And again, it just says down below, if you need something reviewed, just to understand the impact it has or whether it's even effective to begin with, give us a call. I've got another email message in from JR on YouTube, who is asking what the best way is to counteract a restructuring of an employee's job, especially if they're placed on a PIP, which is a performance improvement plan. So JR, just so I'm clear, so you want to know, how do I respond, or how does someone respond to their job being changed, and particularly in the context of that person being put on a performance improvement plan. So if you're an employee and you're put on a performance improvement plan, that means that the employer, for whatever reason, views you as, or views your performance as being substandard. Now, that doesn't mean that it is, and there's a huge issue. There could be a huge issue if you've been placed on a performance improvement plan and you disagree with it. As an employee, you're going to want to disagree. You're going to want to put that on record, because far too often it's happened where someone has been put on a PIP, a performance improvement plan, and they have not been fairly criticized, or the PIP itself is not even reasonable, and that could amount to a termination. So that's one thing I always think about. First of all, is the performance improvement plan legitimate? Are the criticisms valid? Does the employee agree that they're performing at a substandard level than what's expected? Now, the other thing you're mentioning is that there may be a change or a restructure of that employee's job because of allegations relating to performance. So an employer may say, we've given you ample time to perform this job. You haven't done it. So now what we want to do is change your job. Now, again, that could be legitimate. Let's assume, for example, it is legitimate. If you signed up to perform a certain job and they find that your performance is lacking, their response could be to change your job, but I wouldn't suggest that they would require you to change. In other words, a lot of times people get simply let go for not performing in a role. And that can be pretty fairly standard. And if anything, if the role is not working out, and there's no right for them otherwise to change your role, you haven't signed a contract saying they can change your role depending on X, Y, Z, then that could be considered a big change to your job, to what you signed up to do, even if they think you're a poor performer. And you could consider that potentially to be a constructive dismissal. So I would say the best way to counteract to your job being changed, first of all, is finding out whether or not they have the right to do it, regardless of the reasons behind it. And secondly, if you don't agree to the new role, I think you need to object, but also do so knowing you risk losing your job, because they may then respond and say that you're being let go. If you're not going to take on this role, we're going to let you go in your current role. And if that happens, then all of a sudden there's a dispute over whether they owe you severance or not. So in this type of a situation, JR, because there's just so many sort of moving plates, I think it's best that you call in, or whomever's in a situation like this, call in, because we got to go through specifically why the PIP was given, whether there's a right for your employer to change your role in certain circumstances over others, and then lastly, based on all of that, the best way to respond, whether it's to negotiate a compromised role, whether it's to just simply accept the restructured role. Again, maybe because you acknowledge you're not the best performer in the first role, or it could just be simply to reject it and say, no, you haven't given me a fair shake. Your performance improvement plan's faulty. I'm not agreeable to this role. I'm willing to continue doing my current role, my old role, but not this one. So a variety of things could happen there, JR. And I think, definitely best to give us a call and kind of flesh it out a bit further. But it's a good question. It kind of involves a lot of issues that I deal with. And I think it's important for people to know. I've got another question in from Denise on Facebook, who is asking or saying that they've been working as a sales rep full-time for the last 5 years. Their employers recently told them that they're being let go due to lack of sales. And it seems like the company hired a contract worker shortly before this, who is doing their job for much less. And, the question is, can they do this? Can they hire essentially my replacement for cheaper and then let me go due to a lack of sales? And I would say, generally speaking, yes, that's possible. First of all, someone can be let go for any reason whatsoever, as long as it's not discrimination, bad faith. If they're let go due to a restructure, due to a lack of sales, maybe not even a huge lack of sales, could just be a little bit of a lack of sales, then that's completely above board for employers to do, provided they're given a fair and reasonable severance package. If also the employer, on top of terminating someone's employment, hires in cheaper labor, that could be seen as certainly a business decision. I don't know if it would necessarily work out for them in the same way, depending on who that worker is. But that could also be something they could do and have no bearing necessarily on the lack of sales, or at least the argument or the position they're taking that you're being let go to a lack of sales. There could be some bad faith sometimes involved when employers, or I should say employees rather, are told certain reasons why they're let go, and then they find out behind the scenes that that's not the case. Like, for example, you could be someone who's laid off and told you're going to come back, but then you find out they've hired your replacement and they actually have no intention on calling you back. So there are circumstances where that can sort of invoke bad faith damages for sure. But Denise, in terms of your question, depending on how much less they're paying the person, assuming it's above board, legally speaking, both of those situations could happen. It might, again, take a bit more fleshing out to fully appreciate maybe if there's other context going on right there at the moment. But thanks for your question. I've got another one in, or a follow-up one from William, who on YouTube, who earlier asked whether or not there's a way to essentially force your employer to give you certain information by a certain deadline. William's asking what the next step for the lawsuit is when your lawyer starts to review your profile. What happens next? Well, William, to be honest, you're going to have to talk to your lawyer about this. I don't know what stage of the lawsuit you're in exactly. After documents are reviewed, a number of things could happen. You could schedule a mediation. You could go to examinations for discovery. But, again, without having more information, it's hard to answer. And I would just speak with your lawyer and just ask him or her, where the lawsuit's at and where things stand. I've got one last question in before I let you guys go. It's from Janice on YouTube. Janice is asking whether or not there's a new law in regards to the amount of notice given to an employer when quitting, and Janice is a bookkeeper. No, Janice, as far as I understand, there's no change. Typically, in Ontario anyways, I'll say that at minimum, if someone is going to give their notice of resignation, they're required to give at least 2 weeks of notice. Now, that could change depending on what's in a contract that you might have signed. Sometimes There's a contract that might say you have to give 4 or 6 weeks. Now, depending also on the position you hold and the amount of time that you've been at the company, there might be a requirement or expectation to give more notice. I don't think that would be true of a bookkeeper, but it would also just, again, depend on the contract you signed, how long you've been there, and maybe just generally if there is an expectation of notice to be given. But normally it's, for the most part, it's either 2, 4, 6 weeks, but usually 2 to 4 weeks, again, depending on the person. So thank you, though, for your question, Janice. And thanks again for everyone tuning in today. As always, I'll be back to answer any more of your questions. Now, we've got another associate at our firm who's also giving another Q&A session tomorrow. His name's Darren Saul. That's going to be, as I say, tomorrow, 1 p.m., as you see down below there, Pacific time. And he'll be, again, available to answer any other questions you have. But as far as it's concerned for me, thanks again for your attendance, and I will see you all shortly. But do take care until then. Bye for now.